Uh, Now we're in the time for 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. For Ms. Lakin, I would like to ask, what approach would you suggest Congress take to address the court's flawed reading of Section 2 and to further protect voters from discrimination?
Thank you for that question. There are a number of things that Congress could do to rein in Purcell, but any legislative response should ensure that voting rights claims get a full hearing while still leaving room for real cases where injunctive relief shouldn't be issued. And it should also ensure that proximity to an election alone shouldn't be the reason to deny relief. This could look like defining a specific measurable period in which election changes are disfavored for legitimate reasons. This would help to prevent the window during which Purcell is invoked from growing even larger and even more unmoored from its foundations. Congress could also clearly state the public's interest in ensuring free and fair access to the ballot and provide guidance as to how that interest should be weighed against administrative concerns. Congress could also clarify that in deciding whether to stay a court order issued close to an election, that the interests of any voters who have relied on that court order are taken into account and protected.
Ms. Lakin, I appreciate your remarks on Purcell, but I was really concerned about Brnovich.
Yes, my apologies. Brnovich ratcheted up the bar for plaintiffs to establish this discriminatory burden. So any response in our view would at a minimum do two things. First, it should make clear that any voting practice that interacts with historical and socioeconomic factors to result in discrimination against voters of color run afoul of Section 2, and that certain considerations are irrelevant to this analysis, such as whether the practice was common in 1982. Second, it should ensure that state defendants provide some evidence that the restrictive practice actually advances some particular and important government interest, rather than relying on unsubstantiated fears. There are different ways that Congress can do this. Congress could, for example, adopt an approach that codifies relevant and non-relevant factors, as General Clark testified about earlier today. It could also adopt a burden shifting approach modeled on the frameworks for addressing discrimination in Title VII or the Fair Housing Act. This could give guidance to courts as to what evidence a state needs to support an asserted interest and how to weigh that interest against evidence of a discriminatory result.
Thank you, Ms. Lakin. Mr. Greenbaum, Section 2 precludes, should Congress just amend Section 2 to preclude courts from considering one of the more Brnovich guideposts when considering voting denial claims? Or if so, in lieu of these guideposts, what factors do you think the court should be required to consider when evaluating vote denial claims under Section 2 and why?
So I do think, Chairman Cohen, I do think that Congress is going to need to step in and amend Section 2 to address Brnovich. I think what you have in front of you, just like in 1982, Congress had a lot of decisions that it could rely on with respect to how to amend Section 2 to provide for results claims. You can look at the decisions that have come down in various years in various circuits, like the 4th, the 5th, the 6th circuits, that have looked at these claims and have looked at what factors are relevant, going back to the fact of having this two-part test about there being a disparate burden. Plaintiffs have to prove a disparate burden, and they have to show that that burden is caused by the challenge voting practice and the way that that practice interacts with social and historical conditions of racial discrimination. And in all of these cases, the courts, among other things, have looked at the Senate factors from the 1982 report.
Thank you, Mr. Greenbaum. Mr. Henderson, Wade, what is your response to those who would argue that the Voting Rights Act, and specifically Section 5's pre-clearance requirement, is no longer necessary because minority voting registration and turnout are much higher compared to where it was during the Jim Crow era, or higher compared to where it was in 2016 when African Americans didn't realize what President Trump might be like and voted at higher numbers in 2020 to see that there wasn't a President Trump Part 2. Would you agree with the late Judge Ruth Bader Ginsburg's assessment of the court's decision that such an argument was equivalent to throwing your umbrella away in the middle of a rainstorm because you're not getting wet?
Thank you, Mr. Chairman, for that question. And yes, I would associate myself with Justice Ginsburg's comments about the prophylactic role that the Section 5 of the Voting Rights Act has played. First, let me say that as the Census Bureau pointed out with the 2020 analysis, our population has grown. The fact that we have seen a significant growth in population would also suggest that we would see some growth in voter participation based on an expanded population. That voter participation in and of itself does not suggest, however, that there are not problems. As the reports submitted by the Leadership Conference in the 10 states with additional states to follow have demonstrated, in each instance, there are recent and current instances of voter discrimination that belie the notion that indeed our country is operating with full equality when it comes to the right to vote. I certainly think the prophylactic role of Section 5 of the Voting Rights Act is key to ensuring that everyone in our country, not just racial minorities, but others as well, enjoy the right to vote as was intended under the Constitution. But this extra additional protection is necessary and has been borne out, Mr. Chairman, by what we have seen at the individual state level, and that has been documented by our reports.